When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We've been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
We litigate.
And we are devoted to helping you.
Hello everyone. Along with Josh Hayes, I'm Mike Royer, and we welcome you to People's Law School. This program is brought to you by Prince Glover Hayes here in Tuscaloosa. On this program, we deal with issues that are important to you and your family. And tonight's topic on the program is dealing with industrial accidents. Our host for the program is Josh Hayes. Josh.
Thank you, Mike. I'm especially glad to be with everyone tonight to discuss a topic that I am very passionate about, and that's industrial injuries, industrial damages to a person that happens while he or she is trying to provide for his family. Besides the time we spend at home and with our family, a lot of times even more, you're at your job more than anything else. And a lot of times in a split second, an injury can happen that changes your life forever. My firm is very proud to represent the working men and women across Alabama in all kind of different industrial injury cases. We're going to talk about several tonight that are actually real, true cases that we have handled, starting with the first photo that I'm going to show you now, which is a photo of a piece of machinery at a tire plant in Mississippi. This is a case we are investigating now. I do believe it's going to be a viable case that we can hold the manufacturer of this particular machine responsible for a young lady's injuries that happened when her hand got caught in this machine. It resulted in terrible burns and amputations to her hand. They had to do skin grafts from across her body to try to fix the damage that this machine caused. And you see there are appropriate warnings on the machine, and there are things called e-stops. Those are those yellow buttons there, emergency stops. Unfortunately, as the next slide will show, those e-stops did not work in this case. This is my client's handwriting to us describing what happened, and you see there that regardless of why her hand got caught in the machine, whether it's her fault or not, this machine has a fail-safe called that e-stop that is she's supposed to be, they're all over the machine. She's supposed to be able to hit them with her knee, her hand, her head even, and stop the machine. In this case, that part of the machine failed. Why, we don't know, but we will figure it out and get justice for this young lady. Unfortunately, 3 of her fingers were amputated, and I mentioned she's had 5 surgeries so far, was about 20 years old, is about 20 years old, getting her master's degree, was earning money herself so that her parents would not have to foot the bill for her graduate expenses all on their own. So very proud to represent this young lady, and I do believe we're going to be able to help her. Mike, I understand we have a question.
This one comes from Huntsville, Josh. Janelle wants to know, and it's a short question but an interesting one, how severe of an injury is necessary to take legal action?
Yeah, that is an interesting question, and there's not a really good answer to that. It's just really going to depend on the lawyer that you get to take your case. Some lawyers take smaller cases, some lawyers only take larger cases. Lawsuits are expensive. For instance, in Alabama now, it costs almost $500 just to file a lawsuit. Depositions can cost anywhere from $500 to $2,500 per deposition, and that's questions under oath that you can later use in court. So all that goes into whether a lawyer would even be willing to take your case. Obviously, there are only so many hours in a day, and a lawyer has so much time to work on cases. Unfortunately, you have to be pretty injured in Alabama for lawyers to take your case. So it's kind of hard to say from those facts, but good luck to you, and I hope you get better soon. Now let's talk about a little bit about the law in these cases. A lot of people have heard about the Alabama Workers' Compensation Act, and really there are two kinds of cases that you can have. You can have a workers' compensation case, which is typically against your employer, and then you can also have what lawyers refer to as a third-party case. That's against, using the example we just talked about, it's against the manufacturer of the machine. So this young lady can actually have two cases simultaneously. She can have a case against her employer, the tire plant people, and we'll talk about in fact, they're on the screen there. I'm going to go through them in just a second, talk about that act, and then she can also have a case against the manufacturer of the machine. Now, the Alabama Workers' Compensation Act is designed really to protect both the worker and the employer. And I say it like that because except being able to sue for workers' compensation damages, you cannot, under Alabama law, sue your employer for things like pain and suffering or mental anguish or any kind of punitive damages, those kind of important damages that really provide for people later in life. So what does the Workers' Compensation Act cover? You can see there on the screen, the employee receives compensation in fixed amounts for any disabling personal injuries caused by an accident arising out of or in the course of the employment. Those are all very important phrases, as you can imagine, crafted by the legislature over 50 years ago, and they all have particular meaning. What's important to know, first of all, is that I mentioned there are no pain and suffering damages, so what kind of damages are there? They will pay you. They will pay your medical bills, no matter what caused the accident. And even if you caused the accident yourself, your employer, under the law, is required to pay your medical bills. And then, secondly, they're also responsible for vocational rehabilitation benefits. And what that really means, in a nutshell, is getting you back to where you can go back to that same job again. If you can't perform that job, they have to offer you what's called light duty so that you can get back to work again. Some typical injuries there are on the screen. We see these, unfortunately, every day in our practice. Anything from a fall through a skylight that we're going to talk about in a minute, to amputations that we just talked about, significant burns. But you know, a lot of times people don't think of things like carpal tunnel syndrome. That can be covered also, that kind of corrective surgery from repetitive movements at work, such as someone working on a plant line doing the same thing day in and day out. That over time can cause an injury. That is covered under the Workers' Compensation Act. Mike, I believe there's another question.
This has sort of is a question of they said, we said controversy, which I guess you deal with a lot. This comes from Jack in Birmingham. Some merchandise fell off of a storage unit where I work and landed on me and two other people. I sustained back and shoulder injuries, but the company says the accident was our fault. It wasn't. What should we do?
Okay, remember, under the Alabama Workers' Compensation Act, it doesn't matter whose fault it is. If you are an employee, you get injured at work and you notify them, then they have to pay your medical bills and rehabilitation expenses. However, there may be other cases you can pursue. The truth is whatever the jury says it is, right? I may remember a wreck one way, someone else, like Mike, may remember it in a different way. Ultimately, the jury in Alabama is charged with determining what the truth is. You need to get to a good lawyer right away who regularly handles those kind of cases. The schedule is a fascinating part of Alabama law, and what it is basically a list of body parts. An eye may be worth this, while a leg is worth that. It's incredible, but if you pulled out the Alabama code books, that's exactly what it would say. So generally speaking, the schedule provides that when an employer suffers the loss of a listed member, in other words, the loss of a finger, the loss of a toe, the loss of a hand, then they are entitled to 2/3 of their average weekly wage for a certain number of weeks. So let's take a look at what some of those figures are under Alabama law. If you lost a thumb in Alabama, your employer would be required to pay you 2/3 of your average weekly wage for 62 weeks. Not very much, is it? If you lost your second finger, instead of 62 weeks, it's 31 weeks. Again, all this is in the code book. If you lost your big toe, it's 32 weeks. But if you lost your leg, it's 200 weeks. So, you know, it's an incredible thing to describe to clients as they sit in my office. What do you mean I can only get X number of weeks? I'm never going to have my right hand again. Unfortunately, that's the law, and that's what makes those third-party cases that I was talking about earlier so very important. So if anyone at home knows someone who's injured on the job, don't be satisfied with only the workers' compensation case. You need to get to a good lawyer who handles industrial cases. Let them evaluate it and see if there's more to it than just a simple workers' compensation case. The Workers' Compensation Act also covers medical benefits, as we had briefly discussed earlier. However, if you don't give proper notice, which means immediate notice, that day or the next day, then the workers' compensation carrier will not pay for your medical benefits. And of course, they're only going to cover reasonable medical care. So if you hurt your hand, you can't also, for instance, get plastic surgery on a different body part because you hurt your hand. So some common sense areas of the law there. Mike, I understand we have another question.
Susan from Northport has this question for you, Josh. My son was injured when a truck backed over him at a loading dock at work. It was dark and there was no one watching out for the truck or for other workers. He's been told that they talked about safety procedures a couple of years ago, but nothing's been done. Should the company be responsible for his injuries and medical bills?
Okay, absolutely his medical bills. Remember, under the Workers' Compensation Act, they're automatically responsible for the medical bills until you reach what's called maximum medical improvement. In other words, as good as the company doctor can get you, then they've got to pay for that, even if it lasts the rest of your life. You know, loading docks can be very dangerous things, Mike. We've seen this in other cases where there are a lot of moving parts, there are a lot of moving people, there are trucks, there are forklifts. They can be very dangerous, and you know, the fact that they were having some safety talks lets me know that they had had some prior problems. Again, you need to get to a good personal injury lawyer who has the ability, the time, and the resources to investigate fully the facts of this case to see who all can be held responsible. So this skylight case happened right here in Tuscaloosa on top of an industrial building. And the skylights are embedded on this particular building along the same level as the roof line. So this young man fell through the skylight on the left, 30 feet to the floor, landed on his back on concrete. Somehow survived that, but of course was never the same. His dream of being in the military gone, all because the people who put these skylights in did not design them in such a way that you would even know that there's a skylight on the building. We had an expert to analyze this building and analyze the skylights, and he said, hey guys, not just is that skylight a problem, but all 50 of them in this roof, they will not even hold a tool bag. Forget somebody stepping through them. And when you can't see what you're dealing with, and you have skylights that are not intended to last forever, that can be a very common cause of an industrial injury. In fact, we have handled those all across the state, very similar cases where a worker goes onto a building he's never been on before and falls, unfortunately, sometimes dies. Represented some people that have been paralyzed because of skylights that companies do not design away the potential hazards. You can see these are some photos from underneath. The new skylight panel looks quite a bit different, and that's because skylights are not supposed to last forever. They're made of fiberglass. When they're on top of a building, they are continually exposed to wind, rain, snow, any variety of environmental features, and simply put, they do not last forever. All right, you see the tan part in the foreground. That is where they covered the corrugated skylight that failed. You can see that difference in the roof. And so if you're a worker up on the roof, you're trained to look for things, to only step where you know it's safe to step. That one you would be able to see because it's clearly different. But take a look at the interior part of the red circle. There is a black X, and that in the defendant's deposition in this case, I asked him to point me to another skylight. Now keep in mind, this is his building. He's been on there hundreds of times over the 30 years he owned it. He can point out those, but someone who has never been up there before steps right onto the roof, and that is the skylight that a worker is supposed to know about. Instead of painting them a different color, putting a barrier around them, OSHA even requires, if you're not going to do barriers or different colors, you're supposed to do a safety net underneath to at least protect you if you do in fact fall through a skylight. So that's a good real life example of what this particular worker dealt with. Mike, I understand we have another question.
Josh, an interesting question from Monet, who comes from Jasper and asked this question. Much of the safety equipment where I work is old, and I don't even think the fire extinguisher would work. That's concerning. Mm-hmm. Some have asked the equipment be replaced by the company, but nothing has happened. Is there anything we can do?
Yeah, that is very concerning. You know, fire extinguishers are important. They're required by law in most areas of workplaces, especially in industrial cases. What you need to do, Monet, is put this in writing. Send them an email, send them a letter, demand that the supervisor take action. Now, I realize, Monet, that's easier said than done. You need your job. You've got mouths to feed, I'm sure, at home, but you know, fire extinguishers are not anything to mess around with, and you need to report that in writing. The reason it needs to be in writing is because if you report this in writing, they fail to take action, and you are injured, God forbid, then you then are able to sue your employer. That's one of the ways around the Workers' Compensation Act. If you complain in writing, they knew nothing about it, then you may be able to sue them directly. Another type of case that we have recently handled involved this particular ladder at a trucking company's yard. And you see this ladder, which is the new ladder that was brought in to replace the failed ladder, is nice and sturdy. It has warning tapes. It has non-skid steps. It's got two sturdy handles. Even though there are wheels on it, it'll also lock down so a worker cannot move it. The next slide will show you the ladder that failed, which is far less sturdy. It only has a handle on the right side, and in fact, it's not even an approved industry handle. There are federal regulations that cover things like this, and this is just kind of a makeshift ladder that this company had brought out to require truck drivers to use this ladder to get in and out of the back of their trailer. The next slide will show you how they were supposed to use it. See, this is the back of a tractor trailer. My client was a trucker. His first time at this particular plant in South Alabama, rather than using, like he does at every other yard, the steps on the back of his truck to pull himself up into the truck to unload, this company required him to use this ladder. And you'll notice, if you look into the background there, you can see the trees and the grass line. You can also tell this is on a significant hill. They told him where to park. They gave him this faulty ladder, and they made him use it. No surprise that he took a big spill and had multiple surgeries. Again, you would not think something like that could happen. He was just going to work to provide for his family, and because of this company's really reckless nature of trying to move people in and out as quickly as they could in this yard, this particular truck driver was never able to drive a truck again. He was never able to provide for his family, all because this company chose to use faulty equipment. Mike, I believe we have another question.
Dan from Tuscaloosa has this question for you, Josh. My company has us sit through videos about safety, but we just sign in and sign out saying we watch the video, and it kind of seems like a safety shortcut. Should we be concerned that we don't know what to do?
Yeah, it sounds like you should be concerned. A lot of times a person's intuition or gut feeling should be followed, and I think in this case, if they are encouraging you to sign something saying you watch a video but they never show you the video, absolutely you should be concerned about that, and you need to demand to watch all the safety videos. Odds are there are some things in those safety videos that all the workers at your place of employment could learn something from, so I do think you should be careful there. Another kind of case that can be a very dangerous but a good case from a legal perspective, or any kind of case dealing with a table saw. Saws are dangerous, that's no surprise. They are made with destruction in mind. However, there are ways to design away from a person getting their hand, fingers, or other body parts caught into a saw. The blade is underneath the piece of wood there, it comes up from the bottom. The guard, however, did not work in this case, and unfortunately there on the screen you can see the blood that it did not work, and our client here lost his complete right hand because this saw guard malfunctioned. However, what is most interesting about this case is that even if the guard fails, there is now technology in place where saws can detect flesh. So in other words, if you're sawing on a piece of wood, it's supposed to cut the wood, right? It's not supposed to cut your finger, so if it detects the flesh, it will immediately stop. You may get a nick on your finger, you may have some stitches, you will certainly have some pain, but you will not lose your hand like this worker did. This is a relatively new saw. It was manufactured in the year 2015. That technology has been around for 30 years, and these companies that manufacture saws have chosen to put what lawyers refer to as profits over safety. They would rather not pay the extra expense, and it is expensive, to design away potential hazards, and unfortunately this worker lost his hand. This case is pending in Jefferson County, Alabama right now. Mike, I think we have another question.
Josh, we do tonight. This comes from Caroline from Birmingham. A friend of mine worked for a company as an intern, and the fourth day on the job, a cable snapped through and ripped his hand open, and he had to get 40 stitches. Because it was another employee's fault, would there be a responsibility against that employee, or would the company be responsible?
Yeah, Caroline, that's an interesting question, and you know, like most other things in the law, the answer is it depends. Would need to sit down and explore those facts in detail. The first part of your question intrigues me because it says that your friend is an intern. Interns under the law may not be an employee. So if that person is not an employee, then he would not be eligible for workers' compensation benefits. That's good and bad in the sense of if this worker, again, who's not an official employee under the law, may in fact have a claim against the company that he was working for. Remember, what I covered earlier is that generally you do not have the ability to sue your employer except for workers' compensation benefits. However, if there are no workers' compensation benefits available, then maybe that worker could pursue a case against his employer. Either way, even if it is his fault again under the Alabama Workers' Compensation Act, it is what's called a compensable injury because he was injured on the job, provided he gave them proper notice. You know, in addition to the kind of cases we've talked about, our firm has recently handled industrial accidents involving heavy pieces of machinery falling off roofs and damaging people below, such as there was a 1,000-pound piece of rebar that fell on someone in South Carolina. My firm is handling that case right now. Of course, killed the man. No piece of safety equipment is designed to protect you from a 1,000-pound piece of rebar falling on you. Also, roofing felt will fall. So all in all, being a worker in Alabama can be very dangerous. My firm is honored to represent the men and women of Alabama in these kind of cases. And if you have a case, I encourage you to call us. We provide free consultations. Be glad to sit down with you or a family member to see what your legal options are.
Josh, thanks a lot of good information on the program tonight dealing with industrial injuries. Let's make sure the viewers understand the upfront cost of a potential lawsuit. They've seen you on TV a lot, and Bob and Matt and everyone else from Prince Glover Hayes. Make sure they understand what's involved in initial contact conversations when they come to you with a potential case.
Yeah, Mike, there is absolutely no upfront cost. We provide free consultations, and in fact, it goes even further than that. The only way the lawyers, if we take your case, ever get paid is if we win your case. In other words, you don't bring us a retainer when we start your case. We don't get paid by the hour. We're never going to send you monthly invoices like some lawyers do. We are totally invested in your case. We front all the expenses, and the only way we get paid is at the end, and that's if you also get paid.
I would gather then, too, that it's great when I come to you with the case for me to be prepared, have all the information, any documentation, because you have to make a decision because of the cost of bringing a case as whether it's financially makes sense for me and for you, right?
That is true, Mike, but we don't, we try not to put a whole lot of pressure on clients because honestly, when they find us, it's some of their darkest days.
Sure.
They've either lost a loved one, have been terribly injured, and a lot of times their thoughts are not all together. We, in addition to being lawyers, we also view ourselves as counselors. So we, take people through their worst and darkest days, and we will help you cobble together your case. We'll ask the questions. We will do our investigation. We will hire the experts, and we will help you get your case together. So while it's important to have that stuff together, if you can, don't put a whole lot of pressure on yourself. The main thing is just get to a good lawyer and get to one right away.
All right, Josh, thanks very much. The People's Law School is brought to you by Prince Glover Hayes. We're glad you watched this program. We hope you'll join us again next time. I'm Mike Royer for Josh and everyone here. Thanks again for watching. We'll see you next time.
When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We've been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
Get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
we litigate,
And we are devoted to helping you.
It's unique in the sense that you've got a person who's got 40 plus years of legal experience in Bob Prince. And then you've got in myself and Josh, two people who have been here for well over a decade now, which in the law field, you don't see that type of consistency in a group of attorneys working together. And that carries on to the associates that we have in our law firm, the support staff, the investigators. We are a team that has been together for well over 10 years now, and we benefit from the strengths of each other, and we have a track record of getting the clients what we feel is in their best interest.
You know, we really work as a team around here. We are all committed very passionately to the clients we represent. We realize that we're getting them at their lowest point most times, and it's a real honor to represent the people we do. We team up on the cases, we work on them very hard, and when it's time for trial, it'll be more than one of us that goes in that courtroom. At Prince Glover Hayes, it is a true honor to represent our clients. We do so with integrity and hard work.
People's Law School is brought to you by Prince Glover Hayes as a community outreach class offered by the Osher Lifelong Learning Institute.